Hello everyone, welcome to Legal Darshan. In today's video, we are going to look at the case of Association for Democratic Reforms and Another versus Union of India and others. In short, we will call this as ADR versus Union of India judgment of 2024. Now, this judgment, we all know that there was a case relating to electoral bond scheme, which was decided by a 5 judges bench in 2024. The panel of the judges consisted the then CJI Justice Chandrachud, Justice Sanjeev Khanna, Justice B.R. Gawai, Justice Pardiwala, and Justice Manoj Mishra. Now, in this judgment, Justice DYChandrachud, Justice Dhananjay Y. Chandrachud, he is authoring the judgment on behalf of all other judges. And the judgment is being unanimously decided by a 5 judges bench who are ruling that electoral bond scheme is unconstitutional on several counts. Also, Justice Sanjeev Khanna, supporting the struck down of electoral bond scheme, writes a concurring opinion in this judgment. Now, what is a brief background of this judgment goes like. So we will just scroll down to the decisions. Yes. Okay. Yes. So basically, when we look at a brief facts of this judgment, now basically this is arising out of a scheme that is being introduced by NDA government in 2018, by the government of India in 2018, which is the electoral bond scheme, which allowed individuals, companies, and even foreign-owned Indian subsidiaries, so subsidiaries that are located in India, to donate to political parties using bearer bonds. Now, these bearer bonds, electoral bearer bonds, could only be issued by the State Bank of India. Now, the procedure goes like, the person who wants to donate or the corporate entity who wants to donate, he or she buys the bond from State Bank of India, gives it to the political party, and party deposit it in the bank. The problem with this, the problem that petitioners are raising is that the identity of the donors who are donating to the political parties of their own choice, that is not revealed to public and not even revealed to Election Commission of India. And this step was facilitated by bringing major amendments in laws like Section 29C of the Representation of Peoples Act 1951, also the Companies Act, the Income Tax Act also, and the amendments were made to these laws to the extent that electoral bond policy was incorporated. Now, there is Section 182(1) of Companies Act, which removes the cap, which earlier was 7.5% of the profit that could be donated to the political parties. The amendment also, removed the cap that was there in the Companies Act, making the donor companies available to or allowed to, donate unlimited donation to political parties through these electoral bonds. Now, in an investigation that was made by Association for Democratic Reforms, and the data that has been produced by the bench, before the bench by the petitioners, claims that supports that it is also there in the concurring opinion written by Justice Sanjeev Khanna. It supports the claim that 94% of the electoral bonds that were being purchased in that after that scheme, 94% of the bonds bore 1 crore bonds from the SBI. Okay, so 1 crore bonds were constituting 94% of the total bonds that were bought from SBI and transferred in the name of political parties. Now, what is the contention of the petitioners here is that this particular scheme, this particular policy relating to the electoral bonds, it violates the right to information of the voters under Article 19(1)(a). Okay. So there is a right to information of voters given under Article 19(1)(a), which has already been established in the earlier precedents. So one case of Association for Democratic Reforms only that dates back to 2002, it was decided that people have the right to know about the leaders, about the candidates they are going to vote for, and their antecedents should be made available to them in the exercise of right to information of voters under Article 19(1)(a). Another contestation that was made by the petitioners was that such a scheme is violative of free and fair elections because it brings in and it increases corporate and foreign influence in Indian democracy. So one company can be placed outside and its subsidiary is in India, and that subsidiary can donate in a secret form to any political parties. Now there was even a finding that most of the electoral bonds were donated to ruling parties by these companies, by these body corporates. Now, Union of India, which is the respondent in this case, it is claiming that this scheme was brought in as a step to fight against black money. Okay, in this case, we need to understand the contention first, and then it will be a good ground to understand the judgment that is being authored by the judges. So basically, Union of India herein is saying that this step is brought to fight against the black money because earlier political fundings were being done on the basis of unaccounted cash, which was not traceable. Now the electoral bonds are converted into formal banking system, and they are made more traceable, and there is claim that it eliminates the black money that revolves in the electoral market. Now court also is saying that donor anonymity is pardon me, respondents are also saying that donor anonymity is also needed to be preserved. Now when we see the claim against donors anonymity of Union of India, there are two parallels that can be drawn. Okay, at one end, petitioners are claiming. Now petitioner is not merely Association for Democratic Reform, it is also Communist Party of India, it is also Common Cause, a registered society, and also one political leader named Jaya Thakur. Okay, so these people are the petitioners. Now they are claiming that there is a right given to voter under the constitution to know the party, to know the candidate they are about to vote for. Okay, so my right to information is infringed when I am not given the access who is donating to which political party. And respondent in turns are claiming that if you disclose the name, if you disclose the anonymity of the donors who are donating to political parties, that is also an infringement of their informational secrecy that the constitution protects, and that will make them, if you disclose their anonymity, if you disclose their identity, that would make them subject to political victimization by the rival party. So if I as a donor, if I am not donating to party X and I am donating to party Y, and party X is ruling in my state, I might be subject to victimization in a political sphere. That is what the contention of Union of India goes like. Okay, now third contention that Union of India takes is that we do have procedures like KYC, know your customer, compliance in SBI accounts, and therefore the paper trail could be accessible to investigative agencies in case any suspicion arises. The court is also, respondent is also herein saying that the scheme is leveling the playing field for all the political parties who are registered with the Election Commission of India to get banking channeled donations which are clean and which are devoid of unaccountable cash. Okay, now what happens? Supreme Court judgment comes, and so in this case the court is, as we have just opened the case discussion, we have mentioned that the court is striking down the electoral bond scheme as unconstitutional. Okay, now on the first argument, the court says that because here two issues can be found to be framed. The first issue being that whether electoral bond scheme, it is contradictory to right to information of voters under Article 19(1)(a), and second, that whether the provision of the Companies Act that allows for unlimited uncapped donations, it violates the principle of free and fair election. The court is answering both the questions in affirmative, that number one, this scheme is violative of Article 19(1)(a), and also that if we allow unlimited corporate donation, that could also violate the free and fair elections here. Okay, because there is a risk of quid pro quo arrangement, because if I pay for the political party in upcoming tenders or in upcoming opportunities, I would expect that state, the government is the ruling government will favor me, because when the investigation was made in this judgment, throughout the course of this judgment, it was found that most of the electoral bonds were issued in the favor of ruling parties only, right? Now court herein is also looking at the argument of right to information of the voters versus right of informational secrecy of the corporates that are providing the funding, because what if they are subjected to political victimization? So Justice Sanjeev Khanna is majorly writing his concurring opinion on this point, and Justice Sanjeev Khanna is saying that right of informational secrecy cannot be obtained for the corporate bodies who are donating at the cost of right to information that is available to public at large. And therefore, when you avail that in the name of electoral bond scheme, it violates the principle of doctrine of proportionality. It violates the doctrine of proportionality as it was illustrated in the Justice K.S. Kutuswami's judgment, right? And it says that the harm to transparency outweighs the benefits to secrecy. Okay, and we know that only you know such kind of harm can be inflicted in exercise of doctrine of proportionality that justifies the cause. So herein the cause that you need to maintain the informational secrecy of the body corporates from political to protect them from political victimization does not suffice the reason that why the transparency should be violated or should be infringed, right? So court herein is also relying on ADR judgment of 2002, which said that right to information of voters is supreme, and voters do have a right to know the source of political funding. Because you see, if I am a political party, okay, and I am getting a funding from a body corporate X, then what happens? Neither other parties, any other parties that are there, they don't know who is giving funding to whom, and not even the public know who is giving the funding to whom. So there is a lack of transparency in such kind of system. And when you remove the cap on corporate donations as well, which earlier was 7.5% of the profits only, it is arbitrary. Okay, because in that light, even the shell companies will be donating and nobody would know. And if you want to even the loss making companies could donate unlimited funds in such kind of donations. Now court is warning that this scheme can enable the risk of quid pro quo arrangements, which is that if I favor a party once, the party might return the favor, and which is a disproportionate influence in the democracy. Now court is also, as we just pointed out, it is also looking at this one-sided transparency, because it's only me as a political party knowing that I am receiving donation from a XYZ person. But voters and other opposition parties do not have such information, and therefore ruling party gets an upper edge. Okay. So the data, if you want to look at the data herein is also supporting the argument that ruling party got the most funding at that time. Now this is basically the court here is saying that instead of curbing black money into the market, that was the one of the arguments given by the respondent in this case. Court is saying that it is opening the floodgates for many other events as well, and the argument that it is to stop black money, rotation of black money in the electoral market, does not suffice so much in the light of doctrine of proportionality as well. So in entirety, the court struck down the electoral bond scheme. It directed SBI to stop issuing bonds with effect from the date of the judgment. It also directed State Bank of India to disclose all the bond related data, which is who purchased, what were the denomination, who was the recipient, encashment date, to the election commission, which was done after 2019 and onwards. And also said that once this data is given to election commission has a mandate to publish the data within a month of this judgment being pronounced. Okay, so by mid-March, some date was given in 2024 to publish the data on the Election Commission of India website. Now, this case strengthens the principle of democracy in India, because democracy cannot be furnished without free and fair elections. It's a watershed moment in electoral reforms in India, and the case basically strengthens voter sovereignty. The case basically strengthens the right to know of the voters, and empowers the voters to make informed political choices, right? So it also demands accountability, so that no political parties can hide behind legal anonymity, and they are also accountable for the fundings they are receiving. Now the court is also cautioning against that if these electoral bonds exist in the system, there can be a hurdle, they can be a hurdle to transparency, because clean election requires open books as well. That is one vision that is being envisaged by the judges in this judgment. Now this is the case of ADR versus Union of India electoral bond scheme getting completely struck down. I hope you have liked this discussion so far we did on electoral bond scheme. And to watch more such videos, to know more about the cases which are listed in AOR leading cases list, you can watch other videos that are already been uploaded on the channel. This was case number 78 from the list of AOR leading cases, titled as Association for Democratic Reforms and Another versus Union of India. I hope the discussion was useful. Thank you for watching. Please stay tuned with Legal Darshan. Have a great day.